Hello everybody and welcome to Module 8, Unit 3, Module 8. We are leaving psychological disorders and dementia behind. Those were heavy topics, and we're going to go to the light, airy, and fun topic of end of life instead. So first we're going to do, just like always, doing some baseline vocabulary here. The first thing to discuss is terminal condition. Now, separate this from a terminal illness, okay? A terminal illness is something that you will eventually die from. Terminal condition is defined as having an illness that can't be cured or treated, and that the patient can be reasonably expected to die from within 6 months, assuming that the disease runs its natural course. Yes, 6 months is fairly arbitrary. The doctor doesn't really know. Could they die from this in 6 months? Sure, yeah, probably. But again, remember that terminal condition is assuming that the end is near. So, as an example here, a 27-year-old HIV positive patient does have a terminal illness, but they're not a terminal condition, especially if they're seeking treatment. They can live a fairly normal lifespan with treatment. So that's not a terminal condition, that is a terminal illness. Advance directives are statements of patient wishes that are instructions for the healthcare team if the patient's not able to make their desires known and there's nobody else to ask. In the U.S., it's a legal document. It has the same weight as a will, and it's sometimes called a living will in some facilities. Heroic measures, because you'll sometimes see people saying, I don't want any heroic measures taken on my behalf, are radical, intensive, high-risk interventions. They're taken with the understanding that anything else is probably going to not work. So, this is a last-minute Hail Mary kind of thing. Anything that comes with a large amount of risk. An emergency surgery, a super high dose of antibiotics, intubation. All of these have very high risks with them, but the alternative is that very likely the patient will die from the disease or injury they have. Okay, so hospice care versus palliative care. And we'll have more about this later. This is, again, just an overview. We'll discuss this in more detail as we go on. Hospice care is comfort care for patients facing a terminal condition or with the terminal condition. It's generally planned at 6 months or less because of terminal condition. Now, it can be renewed. So if you... Well, again, let's not say you. If a patient goes 6 months and they haven't passed away from whatever they had yet, the doctor can just renew the hospice order and it can just keep rolling. I have worked with patients that have been on hospice for years, literally. No curative plan or treatment is pursued. It's typically done at home. Whatever qualifies as home, home, whether it's your house or apartment, whether it is the nursing home that the patient is in, whatever is home is where hospice it happens. Palliative care is literally comfort care. Provides relief for patients facing severe or life-limiting illnesses, whether physical or mental. Treatment can still be pursued. So you can be on a palliative care track, as it's often referred to, and still be receiving treatment for a disease, as opposed to in hospice where they stop anything related to the illness. Do not resuscitate, and these come in a couple of flavors. Do not resuscitate is a legal order that forbids medical caregivers from doing any kind of life-saving interventions. Now, also there are, you may not have seen these before, are OOH DNRs, or out of hospital do not resuscitates. Prior to OOH DNRs, what had to happen was say in a nursing home, you find a patient non-responsive, you had to begin CPR and call 911. The paramedics had to come out, start their job, take that person to the hospital, and once the patient was at the hospital, a doctor could come out and go, stop. But you couldn't do it until then. So that's where the out-of-hospital DNR came about, so that at that point, now in a facility, if someone has this, somebody comes in, finds that the patient's passed away, they'll just close the door and then go call the family. Some places refer to this as allow natural death or an AND order. I didn't. These aren't common in Texas. It's usually an OOH DNR or DNR. So there are a lot of ethical questions that go with DNRs. For instance, somebody that's on, for like the examples I have here, someone who's on dialysis treatment, someone who has a pacemaker, somebody who's receiving oxygen because of COPD. These are potentially, dialysis is obviously a condition, well, dialysis is a condition, renal failure is a condition that obviously will lead to death in less than 6 months if it's not treated. And so the question is, and this does happen, which is why the question comes up, how can somebody have a DNR order and also still be receiving dialysis? It's not very congruent. Another ethical debate is racial divergence. About half of white patients have a DNR when it's appropriate. Now, obviously, if you go into a hospital for a broken leg, they're not going to ask you if you want to do a DNR for that or something, or like having a baby. That we're talking about situations where a DNR is appropriate. But so yes, about half of white patients have a DNR, about a quarter of black patients do, and about 20% of Hispanic patients do. And I'm sure you're tired of hearing this by this point in this course, but we don't know why. We're not sure if it's a cultural issue, if it's has something to do. Well, honestly, we just don't know. We're sort of unsure. There may be a misunderstanding of what a DNR actually is and does. Again, we don't know at this point. But there's more. There's more. Questions have been brought up of what is the practical difference. Now, please understand, I'm not taking a side here. I am being devil's advocate. But people have come up with, have brought up the question, what is the effective difference between a DNR and a suicide? Or right to die, euthanasia question. They all seem to be relatively the same thing, right? They're all, peace out, I'm done. So effectively, what is the difference? That's, we don't really have a good answer on that at this point. Is there one at all? Who knows? And another one that comes up is dementia. You may have a person who has an order, like put some stipulations in place. I don't want, if I can't feed myself, I don't want to be fed. If I pick another thing here. I don't want to be allowed to wander around, something like that. I don't want treatment when things get more severe. If I'm no longer able to speak for myself, but then as the disease progresses, the person indicates that they do want these things. They're hungry. They're thirsty. The question comes up. What do you do in that case? Do you honor the original instructions, or do you honor the current instructions that seem to be being given? Now, which one's right? Is this person questionably? Let me back up. That this person is questionably a different person at this point, as the dementia progresses. So that is an ethical gray area also. Okay. POAs. Now, stipulation on POAs here. I understand the law in Texas, New Mexico, North Carolina, and Mississippi. Those are the ones I've dealt with. I can't speak for other ones. I assume most of them are relatively the same. Some of these are federal statutes, so they are the same everywhere. But in general, the power of attorney is a legal order authorizing another person to act as a legal representative. Generally, the person who is granting the power of attorney to somebody else is called the grantor. The power of attorney has authority over this person's private affairs, business affairs, legal affairs, and you can, as opposed to Hollywood where you see people like locked away against their will because of some dastardly machinations of somebody, that can't happen. You can set stipulations on a power of attorney. You can say, in case of X, this person will function on my behalf. You can set a time limit on it and say, this order of power of attorney is good for 3 months. There is a durable power of attorney, which means the person who is designated as power of attorney they just stay power of attorney until such time as the person passes away or the grantors. Again, the grantor can rescind the privileges of power of attorney. So I guess a durable power of attorney is in effect until the person passes away or fires their POA. Two other things. The POA may not override advance directives. So if there already is a living will in place by the patient, the power of attorney can't override that. The hospital or the facility in question will go with that. Will follow those instructions instead. The other thing to note is that the power of attorney can be fired at any point, at least in Texas. Even if somebody is found to be not of sound mind, they can fire the power of attorney and have one designated by the court instead. So there really isn't a way for a power of attorney to force somebody into some legal shenanigans that causes problems for them in the future. Now, the other POA is the medical POA. This person has the legal authorization to make medical decisions on the grantor's behalf in case of incapacity. Again, just like the POA, this can be limited to specific circumstances. Obviously, one of the circumstances is if I'm unable to make my needs known, then it can also be for a set amount of time. This person also is responsible for managing medical records, okaying treatment options, discussing them with the care team. They're also responsible for HIPAA management. So this person designates who gets to know what when and what the facility can tell other people. Okay, so medical power of attorney versus power of attorney. In Texas, again at least, these individuals are referred to as agents. And often it's two different people. If there is no medical power of attorney, the power of attorney takes those duties also. Having gone through this and seen it happen many times, I would recommend, if you have anybody in your family with this issue that needs something like this done, have two people. That's a lot to be in charge of and manage. So it's much better to have this nice clean division. The POA maintains the estate of the patient and handles financial affairs and legal affairs. And the medical power of attorney manages the patient's care. It can get very difficult and very tricky for somebody who's trying to do all of those things for this person. Side note, sometimes the POA is referred to as the financial POA. Not very often. I generally see it just as POA, and we all assume this person can and write checks too. Guys, that is the vocabulary for this. When I see you again, we will discuss hospice versus palliative care. All right, you guys have a good one. I'll talk to you later. Bye.